that you had a true fear that that person was going to cause you injury. Now with the Castle Doctrine, you don't have to prove that. If a person has either gained access to a home unlawfully or is attempting to gain access to the home, the homeowner is entitled to respond with deadly force, and it is presumed that they were doing so in self-defense.
I see. Bob, when we talk about a presumption in law, I mean, the word is, you've raised it on more than one occasion. I think I know what it is, but for the benefit of our viewers, what does that mean?
Well, the ideas of burdens of proof, defenses, these are all essentially trial issues. And whenever there's a dispute that can't be resolved by an agreement, a case is presented to a jury. And juries then have the determination of deciding what the facts are. When there's a presumption, the judge will tell a jury, it's not really for you to decide. We are going to presume that facts are a certain way if you hear this type of evidence. So if a jury would hear evidence that a person was wrongfully trying to get in to the house,
yeah,
they're not to consider whether or not the person, the homeowner who responded with force acted reasonably or not. They're just to assume it. They're supposed to essentially take it for granted that the homeowner was acting appropriately by responding with deadly force.
I see. And that's kind of where this whole Castle Doctrine is growing, to establish or broaden that presumption.
Yes.
I see. You say other states have done this?
There's about 20 states that have, don't ask me which ones they are, John, but there are about 20 of them that have similar statutes that have taken that burden away from a homeowner to prove that they acted appropriately, and we just assume that they act appropriately until until the state of Ohio, the prosecutor, would provide evidence to suggest otherwise.
Yeah. Well, I'll bird walk with you just a little bit. You spent some years as a prosecutor. Did you ever have anything that came up under the old law that you might contrast to this?
Boy, I'm trying to remember if I had some self-defense cases as a prosecutor, John, but none of them really that occurred inside somebody's home. And frankly, if an intruder's inside somebody's house, even under the old law, I think it would have been very difficult for a prosecutor to beat a self-defense claim in that situation. Even under the old law, if somebody is in their house and there is an intruder in there that's showing them ill will, even under the old law, that homeowner was going to be able to make a self-defense claim. Where this is significantly different is that, you know, the intruder doesn't have to be inside the house anymore. They can just be trying to gain access. And it's not just homes. It applies in vehicles. So if somebody's in their vehicle and somebody's trying to gain access to the vehicle,
wow,
there's the presumption that it is appropriate to respond with deadly force. And I use the term home, and it was probably erroneous. The statute defines it as residence, and then defines residence at a place where people would be expected to essentially be spending the night. So hotel rooms can be a residence that can be defended with deadly force. Even a tent in a campground could be a residence that could be defended now with deadly force.
Well, and maybe for another show another time, but Ohio does have a concealed carry weapon now, which it's my understanding with the proper training and whatnot is perfectly legal for an Ohioan to carry a gun. That's correct?
Yes.
Well, I mean, one might affect the other now that we're talking about vehicles and residence. I suppose, though, that I guess just before we leave self-defense, talk a little bit, leave it and talk a little bit more about Castle. But self-defense, Bob, a person could use self-defense in a reasonable way. And I guess that's the part that's, you know, maybe some of our viewers might kind of find interesting. Could you use deadly force if somebody was stealing your lawnmower?
No.
Well, how? But there's seemingly there's a difference here coming now, because now we're talking about the car. Is the guy trying to steal the car?
Well, in order for the new law to apply to you, you have to be an occupant of the vehicle. So you have to be in the vehicle at the time the intrusion has taken place. So you wouldn't be allowed to sit on your front porch, see somebody trying to steal your car, and take aim at them.
I gotcha.
But if you were inside the vehicle at an intersection, say, and someone came up and tried to gain access to the vehicle, it would be presumed that you were acting in self-defense if you responded in that situation with deadly force. Now, if you're outside the vehicle, if you're walking down the street, the old rules of self-defense would apply in that situation, and they're different than even what we've talked about so far. If you're on the street, you can't be responsible, in order for self-defense to apply, you can't be responsible for creating the situation. Okay, so if two guys are getting into an argument in a bar, that person